Good morning, everyone, and welcome to the Ray Law International channel to our live stream today. We're going to give a few minutes for people to get logged on and make sure that as we get started today, everyone hears what's going on. My name is Anthony Ray. I'm one of the attorneys here at Ray Law International. We are an immigration law firm. We represent clients throughout the United States and throughout the world. We do about 80% employment-based immigration, and we also do some family-based immigration as well. So today, our topics is all going to be about getting that green card through the EB-3 process. So we're excited to talk about that, but we're also excited to hear questions from our audience. We're here for you guys. So please, the chat is always open. Please go ahead, put your questions there. Feel free if you want, you can call in, make an appointment, or call in and ask a question, and there'll be someone there to assist you and help you with whatever your immigration needs are. So just sit back, relax, but make sure you put a question in there. Say hi. When we get to our question in the middle, our get to know you question, feel free to chime in and let us know, your answer to that question as well. So I'm going to turn it over next to Lauren. Take it away.
Hello, my name is Lauren. I'm one of the attorneys here at Ray Law. I work out of the Chicago office, and we handle employment-based and family-based as well. If you, again, like Anthony said, if you have any questions, feel free to leave them in the chat. They can be about our topic or they can be about something else, and we'd be happy to answer them for you. Saki?
Good morning from Chicago. My name is Saki. I'm a legal assistant at the Chicago office. Today's Chicago weather is really nice and warm. I'm pretty happy to start the morning with. And also for Japanese people, もし、そうですね、今回のライブストリームの件に関しまして、ご質問ですね、等ございましたら、どしどしチャットの方にコメントしていただいても結構ですし、また、そうですね、お問い合わせの方法で、下に載ってます電話番号、もしくは、E メールアドレスも載せておりますので、そちらの方にご連絡いただければと思います。よろしくお願いいたします。Okay. All right, so I guess we're ready to start today's topic. So first question is to Lauren. What is the labor certification process and then why do we need it?
So the labor certification process is for employment-based green card petitions. It would be the first step in the process, and I'm going to simplify it a lot. Definitely speak with an attorney because these things get really complicated. But in general, the labor certification process is a process where you submit all of your information about the position to the Department of Labor. The Department of Labor will then come back and say, okay, with a typical job in your area with job duties like these, you should pay a salary of X amount. This is to make sure that you're not paying an immigrant a lower wage because it's cheaper and thus are excluding US-based workers. Once you have that, you need to test the labor market. That's what they call it. So you have to place some advertisements, run a job bank to notify potential US workers or green card holders about the position. If no one applies or someone applies and you decide to hire that person as well as the immigrant, then you would proceed and fill out the form ETA 9089, which is also called the labor certification. So that has information about the position, about the candidate, and about the recruitment that was done to test the labor market. The DOL, or the Department of Labor, will then take some time, review everything, and certify, is what they call an approval, basically, your petition. Once you have that, you can go ahead and proceed to file the Form I-140, which is an immigrant petition. The labor certification is used for, maybe the EB-2 or EB-3 categories. There are some categories that do not require labor certification, but you would have to speak with an attorney to figure out kind of if you would qualify for those exemptions. Saki?
All right, thank you, Lauren. Wow, that's a lot of information to start with. Okay, so who is the EB-3 category for? Are all EB-3 candidates subject to the labor certification process? This is a question to Anthony.
All right. Thank you, Saki. The EB-3 category is really for everybody. That means anyone who wants to come to the United States and live permanently here in the United States. The nice thing about the EB-3 category is that it's divided into 3 subcategories. The first being professionals. Those individuals with a degree, could be an advanced degree. Think of doctors, lawyers, accountants, engineers, and many, many other professions, all in the medical field, sciences. I mean, there's hundreds of positions that qualify for this. So even though we may talk about the few, the top 10 or so, there are hundreds of positions that come under the heading or the subcategory of professionals. The next category that people will fall under are those individuals who are considered skilled workers. Those are individuals who have, trades or skills and at least 2 years of experience or 2 years of training. Okay. And this is great for a lot of, from plumbers to construction to all kinds of positions that don't meet the professional category. The third and final category or subcategory is going to be our unskilled workers. This is everybody else. Years ago, this category was limited, so certain positions, were ineligible, but they did open it up, thank goodness. And as we see now in the U.S. job market, there's a strong need for more workers here in the United States. So, I encourage everyone out there, if find a U.S. employer that's willing to sponsor you. There are several companies out there that will assist in finding some employers. We don't advocate or introduce them, but there are several out there that, support various industries where there's a lot of workers that are needed, from agriculture to, construction, landscaping, all hotel, home care, pretty much everything you can think of, there's a category. The nice thing about the EB-3 category, remember, is that you're bringing the person in permanently. So if you find a U.S. employer, or if you're a U.S. employer and you want to bring someone over, these are the options that you have. And, feel free, we'll get in a lot more detail with you on a one-on-one, but we're just giving a quick overview today. And, we'll see, feel free to give questions. We'll get into a little bit more detail, but those are the 3 categories, and, anyone can really fit into one of these categories.
Okay, thank you, Anthony. So Lauren, as an employer, I have too much to do. So can I have the beneficiary foreign national handle the recruitment at this stage while I oversee her? You're muted, I think.
Sorry about that. So in this case, the answer would be no. The foreign national cannot be in charge of recruitment. We do not want the DOL to think that there is some impropriety going on, that maybe the foreign national saw a resume that would have worked and that you could have hired them and they kind of pushed it under the rug. So definitely no, you do not have to handle it yourself as maybe the main employer. It could be someone in HR, it could be some other sort of manager in the firm or in the business. It just definitely cannot be the beneficiary or the foreign national. Saki?
I see. Thank you, Lauren. So Anthony, as an employer, what forms of recruitment can choose? What are my options?
Yeah, so there are several forms of recruitment that is required, and it really depends on what subcategory you're filing under. For our professionals, there are generally 6 forms of recruitment that are required. Under the other categories, under the skilled and unskilled, the number of recruitment that is required is reduced. It's something a lot more reasonable. So to give you an idea of what some of this recruitment looks like, the 6 forms for professional. The first one would be 2 Sunday ads in a Sunday paper. In a major paper of circulation, 2 Sunday ads. They have to be consecutive in a major paper circulation. Think New York Times or Boston Journal or Detroit News or Chicago Tribune. Those are certain papers that you would post so that it really reaches the broadest number of people to see if there are U.S. citizens there. Next would be the job bank. It could be on the America's job bank, or it could be on the individual state job bank. A job bank is basically a place where employers can post jobs based on the states for people who are looking for work or may be on unemployment. So those individuals, that's a good place for them to use that. Next is an internal posting within the company. Within the company, employers are supposed to take this job description and offer and post it in their place. Usually it's in a cafeteria or wherever the company has their job postings noted. Now, in addition to these 3, there are 3 additional ones that an employer can choose from. And the list is, it's very broad. It could be a job fair, it could be the employer's website, it could be on-campus recruiting. Maybe the employer has a private professional placement agency looking for them. Referral program within their firm works also. Radio, television, ethnic newspapers, even campus placements at universities and colleges are examples of where employers can post. So depending on the employer, there are some options, 3 which are set and 3 which the employer can choose. So this is an example and kind of what you can expect during the recruitment process.
Okay, thank you, Anthony. All right, so I got lots of information about the recruitment. But Lauren, what are the benefit of the labor certification program? Does everyone get approved?
So no, not everyone gets approved. Definitely speak with an attorney because the DOL is very picky. If you have one tiny, tiny error, there will be a denial and it is very hard to overcome. You can always file again. However, in that case, you're facing kind of a long period of time. That being said, if everything is correct and you've done everything properly, they will 100% approve you. So in that case, you can be confident that you'll move forward with your petition and you won't have any problems in the future at the next stage of the I-140 or the immigrant petition. So I guess that's a benefit. There's not really many benefits. I hate the labor certification just because it is so extensive and the processing times are so bad right now. But once done, it is pretty pretty guaranteed going forward. It looks like we have a question in Spanish. Yeah,
Lauren, why don't you prepare that and answer that after my question?
sure.
And that way I give you some prep for that. You can do it in English and Spanish, okay?
Okay.
Go ahead, Saki.
Okay, so all right, I got lots of interesting information. Anthony, so what are some problems with the labor certification process? Will the process improve?
What are some of the problems? Now, Lauren just mentioned some of the issues and problems with, I'm going to highlight a couple more. I'm going to focus on three. First, the process is slow. Second, the process is rigid, which, Lauren touched on. And then the current processing system is totally out of date. So the first one, the processing process is slow. Basically, to file a labor certification, it can take anywhere from 6 months to 18 months. So when the government is doing really good and they're on top of their game, we can do the recruitment as soon as we file it with the Department of Labor. We can get certification within 6 months. That's the best case scenario. Earlier, we've had some people do it sooner, but on average, the best case scenario is 6 months. Now, on average, we're looking at about a year right now because a lot has changed since the golden days of labor certification immigration. And if there is an audit is basically the government verifying that all the recruitment was done properly. Now, the current process is sort of a good faith process. It's in good faith that the employer actually did the recruitment. And theoretically, it could be approved without verification. However, of course, we always want to be honest and truthful and do the right thing because that's why an audit could come up. It's a random audit, and those audits test to make sure that employers are staying on the up and are doing what is right. So an audit allows the government or Department of Labor to review everything and then give a decision on the case, whether that's an approval, certification, or whether that's a denial. So because of that audit process, the case could run all the way up to 18 months just because that's how long it can take. So the process is slow. It'd be really nice if the Department of Labor could come up with a system and get us down to about 6 months. I think that would be beneficial to the beneficiary and to the employer because that'll speed up the process. Second, the process is really rigid. As Lauren mentioned, one mistake, it's over. Basically, when I say it's over, I mean you can't go back and correct it, or there's no discretion really granted. You can always appeal, but it doesn't give you any protection. The appeal does not cost money right now. They were thinking about charging a fee for it, but it doesn't cost any money, but it's slow, even with that appeal process, and there's no guarantee that you're going to be approved. Therefore, refiling everything costs money and time, so it's a rigid system. There needs to be some flexibility in there so that if someone has a typographical error or if someone failed to fill in a spot, they're able to rectify that problem and keep the case going and get it approved. It should be something as to, is the problem or error material to the actual application getting approved? And in many cases, it's not. Finally, the current process is extremely outdated. How many of you guys out there actually looked for your last job in a Sunday newspaper in the classifieds? Probably nobody. I don't think I've ever looked for a job in a Sunday newspaper. I've glanced over it a couple times when I wanted to buy something or maybe a garage sale, but never to find a job, let alone, for example, a position to become a lawyer. However, the government is making us or forcing us to post in Sunday newspapers. Additionally, newspapers, unfortunately, are trending out of our mainstream media source that we get our information from. So when there's fewer papers, that price for those classifieds goes really high. And it's mind-blowing the ad cost that you would have to pay in Texas or New York or a major city. A simple ad could easily run you a couple $1,000s. And, that's even limiting the ad. So the process is outdated. It never, gets the person you're looking for. We had one for a company where they were looking for an engineer, and not a single engineer applied using these 6 methods of recruitment. None. So the system is outdated. It needs to change. Now, the current system benefits the employer because they want to hire that person and they never get any resumes. Whereas if they improve it, that hurts the beneficiary because, if you target engineers like in where engineers look for work, or if people are forced to use an agency to find an engineer, then that's really going to force the U.S. employer to, look for, American workers who, they're there. Engineers are there. Computer systems analysts are there. Market research analysts are there. It's just the way that they're asking us to find it is so outdated. And unfortunately, Congress or Department of Labor would have to change their process and procedures in order to modernize the U.S. immigration policy. I think they should really just throw the whole thing out and let professionals, at least those with 4-year degrees, apply directly for a green card. We need people in those positions. And then for the other positions, such as skilled or unskilled, come up with a system that makes sense for, the U.S. economy of where we're at right now and as we move forward.
Okay. We have a question. So first I'll address it in Spanish, and then I'll address it in English, just in case anyone else was wondering. Hola, Aislinn. Su pregunta es, estoy pidiendo a mi hermana con su hija. Mientras siga el trámite, ellas pueden quedarse en USA a esperar su residencia. Desafortunadamente, una petición para un miembro de su familia no dice que esta persona puede quedarse aquí durante el proceso. Una petición para una hermana puede tomar 10 años hasta 20 años para que el fecha de prioridad es corriente. Entonces, pero su hermana puede y su hija puede quedarse aquí con otro tipo de visa. Posiblemente hay un empleador que quiere hacer una petición para ellos, si ellos tienen si la mamá tiene educación como un título o maestría, posiblemente otro miembro de su familia como un mamá o otro miembro puede hacer una petición que es un poco más rápido. Entonces, favor de llamarnos para un poco más información para discutir su caso. And Aislinn's question was, I am petitioning for my sister and her daughter. While the petition is pending, can they stay in the U.S. while they're waiting for their residency? And the answer to that is no. The immigrant petition does not guarantee or grant any sort of status while it's pending. So they would have to wait outside the US. However, if they did obtain some other sort of visa, then yes, they could stay in the US while it's pending, such as, if the mother had a bachelor's degree or master's degree, and there was an employer who wanted to sponsor them, perhaps this person could come on an H-1B and stay while it's pending. I also noted that the petition for sibling can take 10 to 20 years for the priority date to become current. So perhaps another family member, maybe a parent, could petition. That will still take some time, but at least it's not 10 to 20 years. So things to consider. If anyone has, like I said, a question, please feel free to put it in the comments. And I invited Aislinn also to just give us a call so we could discuss her case specifically. Definitely feel free to do that. We do have 15-minute free consultations. Saki?
All right, thank you, Lauren. So I think we got lots of information for labor certification process. So let's talk about the next step, immigrant petition. So now that we got our application for labor certification approved, so what's next? Do I get the green card now? This is a question to Lauren.
Um, in this case, the next step would be to file the immigrant petition, which is the form I-140. And depending on what country you are from, potentially the form I-485, which is the green card petition. So, for example, we have many Japanese clients for the EB-2 and EB-3 categories and EB-4. Japan is going to be current. Which means that there's not a long line of people waiting to get a green card based on this category. So those people can automatically jointly file the I-140 and the I-485, which is the green card petition, together. For people such as maybe Indian nationals, where there are a lot of people applying in these categories, they would just file the form I-140. That would grant them what's called a priority date. It's basically like a place in line, a placeholder in line. And once the Department of State says that the priority date is current, could be 10 years from now, then those people can apply the second step, which would be the I-485 or the green card petition. So once those are approved, then you would get the green card. It depends what country you are from. Definitely go ahead. Anthony's putting up the visa bulletin right now. So you can go ahead and look and see what your country falls under. Many countries are just the all chargeability area. So unless your country is specifically listed, India, Mexico, Philippines, El Salvador, Guatemala, those countries, you would fall under all chargeability. So those, if you can look, they are all current, which is great. So those countries, yes, you can immediately file. But for other countries, such as India, China, definitely depends. You would need some other sort of visa to keep your status here in the US. And Esleen had another question, where is your office? We have offices in Chicago, New Jersey, and in Michigan, but we do help clients all over the US. We have a lot of clients who find it easier because we do pretty much everything through the computer, email. If you're comfortable using email, then it would be an easy process. If you're not comfortable using email, perhaps, yes, you would want to, visit us in person if you're nearby. And, if you're nearby, come say hi. We'd definitely love to see you. But, otherwise, maybe a different attorney would be better. Esleen, ¿dónde es su oficina? Tenemos 3 oficinas, uno en Chicago, uno en Michigan y uno en New Jersey, pero tenemos clientes tras de todo el país. Si usted está cómoda de usar email, podemos tomar su caso. Es muy fácil para nosotros hacer todo desde la computadora. Si usted no es cómoda de usar la computadora, mejor que usted viene a la oficina o buscar otro abogado, pero si usted es cómoda de usar la computadora, es muy fácil para nosotros hacer todo el proceso y probablemente es un poco más fácil para usted también. Saki?
All right, thank you, Lauren. Okay, so I guess the next step is immigrant petition. So Anthony, what are the fees I can expect at this stage of the green card process? And then who has to pay?
Thank you, Saki. At this stage, at the immigrant petition stage, basically, if you want to keep it simple, it's one fee. Now, nothing's cheap with the USCIS anymore. Just like we're all experiencing inflation in many areas of our lives, immigration is one of those areas as well. The immigrant petition fee, the main petition, the I-140 as it's also called, the filing fee is $700. Now, if you want, you can just do the normal processing time, and it can take anywhere, depending on the service center, anywhere from, I would say, 6 to 12 months. You can just wait and let the USCIS process your case in order, which is perfectly fine. However, some of you guys out there want your case, you want a decision a little sooner. So the government has introduced, what's called premium processing. You can request premium processing at the beginning of your case. You can request premium processing in the middle of your case. So at any time you want to give the government a few extra dollars, you can do that to speed up the processing of your case. Now, remember, the regular processing time can take anywhere from 6 to 12 months. Now, if you want to make that shorter, you can give the government just $2,500. Give them $2,500 and they will speed up the process for you gladly. That time, or the shorted period of time, is going to be 15 calendar days. Now that's pretty good. 15 calendar days as opposed to up to 12 months. That's a huge difference for many people. So if you don't have a lot of patience like me, you want to, if you've got a cool 2,500 sitting aside that you can just give to the government so they can do their job quicker, at the beginning of the case, you can file your request for premium processing together, get approval, or you can midway through say, hey, this is taking a little longer, or maybe there's some other circumstances that may require you to speed up the process. Maybe your status is expiring, or for example, maybe you're reaching the 6-year limit for the H-1B, or maybe a category you're in is about to expire and you need to go ahead and get the third and final stage, the adjustment of status process, underway. Then filing premium processing is going to expedite that. So as just a quick review, $700 is the fee for the main petition. That's all you need to pay. And then the second part is the $2,500 if you want things to be sped up a little bit. Now, this doesn't include attorney's fees. Feel free to reach out to us to see what it costs for the attorney to put this all together so that it gets done properly and smoothly, and that you can have peace of mind as your case continues to process.
Thank you, Anthony. So, Lauren, what does ability to pay mean? Why should I care?
So the ability to pay means that the employer has the ability to pay you the wage. So I talked earlier about the first step in the process being that you would, or your employer would, submit information about the petition, about the position, and your location, and the DOL will come back and say, okay, a person in your area with this type of position should be paid X amount. So your employer needs to be able to prove that they have the ability to pay that amount. You would prove that most easily through a financial statement or through federal tax filings, right? Showing that the company makes that much money. If the company is not showing a lot of money, either because they don't have the cash on hand, or through accounting practices, they are just minimizing their tax liabilities. In that case, there are other things we can do. We can try to show assets. We can try to show cash and bank accounts. There are other things we can do. It is more difficult, but there are things to be done. So you should definitely care, because the employer does have to pay that wage once you get the green card. During the process, the employer does not have to pay that wage, but after you get the green card, they will. And USCIS is really going to look into that, because they're really concerned that the company is paying foreign workers the same or better than they would pay U.S. workers, so that U.S. workers aren't shut out from the position just because a foreign national will take a lower salary. Saki?
Okay, thank you, Lauren. Well, I guess we are learning lots of things right now and then need a little bit break time right now. So let's go to the fun questions to take a break. I'm going to ask Anthony, have you ever met anyone famous?
All right, so I have not met a lot of famous people, but earlier in my practice, I was working at another law firm, and a Detroit Tigers player, the professional Detroit Tigers team, a player came in, and he needed some assistance. So at that time, I don't know how he found our office. I don't know. He just turned up. We said we can handle it. We took care of him. So at that time, I don't know, maybe 15 plus years ago, Marcus Timms or Marcus Themes, I can never pronounce his name correctly. He was with the Detroit Tigers, an awesome hitter. I think his last position was on the New York Yankees most recently. But he was just a great client. I think my kids really are never going to forgive me because I never got a signature or autograph. And I was always wanting to keep things very low key, not be the type person to ask for this and kind of be that ridiculous fan. But yeah, that was probably one of the famous people. I've met a few others, but Marcus, he was just a great person, a great client. Everything went very smoothly and a great couple. So that was probably one of my most memorable. We've had some more recent ones from the Tigers and others that we've handled some work for, but that was one of the highlights out of the past for me.
Wow, interesting. How about you, Lauren?
I love your inflections. So if we're talking about Met, Anthony's story reminded me. I did used to, when high school and college, when I would come home for the summers. I am from a town named Hinsdale, and I worked at a place called Baldinelli Pizza. And one time, a Sox player came in, or possibly regularly. I don't know who these people are, so I had no idea. But one of the other employees did tell me that he was a Sox player. So I met someone. What about you, Saki?
I saw someone. I don't know if it's count as I met someone. It was from my college. The James Franco was taking the our summer class for like a writing and stuff, I think. And I didn't even realize it, but I was just trying to take a nap on the couch after the lunch, and then realized that someone's sitting next to my couch. My friend told me after I woke up and left the couch, and they're like, "You didn't notice him?" And I was like, "Who?" And then they're like, "That was a James Franco." And I was like, "Who?" I'm not familiar with the people's name and stuff. So I totally missed the chance to say hello to him, but I was taking up right next to his couch. That's all I can say. But yeah, that's the famous person I met. Okay, so I guess it was a fun time. All right, now we're going back to our study time. So next question is to Anthony. So I heard that the foreign national must be in the U.S. When the immigrant petition, so for the form I-140 is filed. But is it true?
Very good question. One of the things you'll find out about immigration is there's a lot of rules and it all depends on something else. So it depends on a couple things. So generally speaking, the statement that you must be in the US when the I-140 is filed is generally not true. But it depends on how you're filing that I-140. Now, when you come to the I-140 stage, you have two options. You can file it with the intent to stay in the U.S. as if you're holding a lawful status in the U.S. For example, H-1B, E, L, something along those lines. Alternatively, you can file your I-140 or the Immigrant Petition with the purpose or goal of obtaining an immigrant visa abroad at the U.S. consulate abroad. So if you, for example, are in the United States as an F1 student and you still plan to go back to your home country after your education and finish up the process abroad in your home country, then you can file the I-140 and have it, everything sent once approved to the U.S. Embassy abroad. Now, again, it's going to depend on how you want your case to flow. It also depends on your current non-immigrant status. So what we're going to do as attorneys, we're going to pull that all together for you, think through the whole process, avoid the pitfalls and problems you will face based on your non-immigrant status, and make sure that everything goes smoothly. So the statement in and of itself, generally speaking, is not true, but you have to look at the totality of the facts and circumstances. So talk to us, give us a call, reach out to us, or if you have a specific case, put it in the chat so that we can address that and kind of look at that specific scenario.
Okay, thank you, Anthony. I have a few more questions. So, we just found out the foreign national degree is not equivalent to a 4-year US bachelor degree. Will this be a problem?
Under the EB-3 category, it really depends on what category you're filing under. Now, I'm going to be asking, we're not ignoring Lauren. She did a lot of work in Spanish last week on our Spanish live stream. So I'm going to answer a couple more questions to give her a break and get ready for her questions coming up. But if the position is under the professional and it's requiring a 4-year degree, and if your degree is not equivalent, then yes, it can be a problem. That's why it's so critical that a proper evaluation is done at the beginning of the process so that later on you don't have a problem at this stage, the immigrant petition. You don't want to do all that recruitment, spend a whole year, a year and a half to get to this point and find out that, that degree you thought was a four-year degree from, Pakistan or Mexico or from wherever is not equivalent to a 4-year US degree. That's the key. It may look like a 4-year degree, it may say a 4-year degree, but it's just not equivalent to a 4-year degree here in the US. Or it may be from an institution that is not accredited or is not recognized. So you really have to be careful. So the proper process is to make sure that it's equivalent. Now, this is only for the professional category. Now, if we're in the skilled or unskilled, and a person has a degree that is not equivalent to a 4-year degree, then, there's a lot of leeway here. That 4-year degree may not be required. We could just say any degree, 2-year, 3-year, 4-year, and that would be sufficient for the skill. For unskilled, that's not needed, So a thorough examination of the process will help us determine whether it's going to be a problem or not. And make sure, if you don't have us as your attorneys, that is done at the very beginning, not, a year and a half later, and the attorney asks you to spend another year and a half going through the same process all over again.
Thank you, Anthony. So one more question. Can I travel outside the US while the immigrant petition I-140 is pending, like if I want to go vacation?
So again, with immigration, it's going to depend on various things. It's going to depend on your non-immigrant status. Generally speaking, absolutely, you can travel. There are some problems that it may arise. Let's say if you're in a category that is not dual intent, then that could be problematic. Maybe you're in a J1 or F1 or even an E. That may be problematic. We don't know what CBP is going to do at the border. They may enforce the law. They may not know the law. They may make an exception. The key is we don't want to gamble with your immigration status. So the key is get a proper evaluation. If you're in a dual intent category, such as an H-1B, such as an L-1, then absolutely you can travel. Now, it also depends, are we filing the I-140 by itself? Or are we filing it together with the application to adjust status? If it's filed together with the application for adjustment of status, then we're going to say, no, you can't travel until you go ahead and get that travel document. However, if it's filed separately or independent of the I-485, then yes, there'll be a lot of liberty to travel. However, you just have to figure out what those circumstances are. Talk to us, we'll help you, we'll make sure that it goes very smoothly and that you won't run afoul of CBP when you try to enter the United States, or worst case yet, get your petition or application denied because someone didn't tell you that you could not have traveled.
Thank you, Anthony. Okay, so labor certification, immigrant petition. I believe we're getting closer to the green card. So Lauren, what are the forms required at the adjustment of status stage? Why do we need so many forms?
Um, sorry, Saki's just killing me. I love it. So, um, the forms required are the 485. There are other forms that you can file with it. That would be the I-765, which is the work permit, which depending on the type of visa that you have, you may have to file in order to be able to work while your application is pending, as well as the I-131, which is the advanced parole. And that's basically, you can think of it as a travel document. If your status runs out, or if you're again in one of those visa categories that doesn't allow dual intent, you can use that advanced parole to re-enter the US. Like Anthony said, there is sometimes pre-processing available for the I-140. So if you're filing the I-140 with the adjustment of status, you would file the form I-907 together with that. Finally, if you have family members, you would need to file the form I-134. This form is basically stating that you will support your family, that the petition is for you, you're the person who's employed, you're going to support your dependents, and they will not become what's called a public charge, or they will not require government benefits, things like that, in order to survive and live in the United States. Why do we need so many forms? I don't know. The government. Um, the I-765 and the I-131 you can file independently, so it does make sense that they are separate forms to be included in there. Saki?
All right, thank you, Lauren. So, Anthony, our sushi chef, is still working in Japan. What forms will be required for him to obtain his immigrant visa? What's the process?
Yeah, Japanese is really tough. I can't speak it well either. So, anyways. Yeah, so once we get to the immigrant visa stage, our forms are the main form we're looking at is Form DS-260. That's our application for an immigrant visa. It's a long form. It changes depending on your education, your employment history, and it just could get longer and longer and longer. But that's the main application. This application is to allow the Department of State, the U.S. embassies, to collect all the information, do their background check to make sure that they know everything about you, your history. They want to make sure that you're a good person. There's no criminal background, you're in good health, meaning you don't have any communicable diseases that would ravish the U.S. So those are all what they do at that stage. Now, depending if you have family members, you may need to file for an affidavit of support for your family members. That's usually Form I-134. Each embassy is going to be a little bit different, and they're going to have their own requirements. So check it. Those requirements change pretty much every year. So just because you did it last time, maybe a couple years ago for an employee or a family member, you're going to want to check again to make sure that nothing has changed and that those forms are still required. It would be really great if the Department of State sort of centralized and had the main process at each U.S. embassy and post just have harmony so that the process could go smoother. However, unfortunately, the Department of State has left it up to each of the posts to come up with how to do the process no matter, however they feel like it. So for that reason, we've got, 100 plus different options and processes depending on where the post is located. Now, for some on the family-based side, they would include the application for adjustment of status. That's the I-864. And then in addition, there's the medical exam. Now, the medical exam is required by a designated physician, and that physician is going to create the forms normally for you. You won't need to create that medical form and fill it out. They're going to have that prepared based off of your application and your passport information. So those are the things you're going to pull together as a form. You'll do your DS-60 online. If an affidavit is required, you'll submit that online. And then you'll also upload all the documents such as marriage certificates, birth certificates, any financial documents that are required, any criminal history, any marriage or divorce history documents. All of that's going to be uploaded so that that immigrant officer at the consulate or embassy is going to review all that prior to your interview. Now, once all that's been submitted, and once you've done your medical exam, and you've done your fingerprint, your biometrics, they've checked in your country to make sure there's no criminal history or background that would prevent you from getting the immigrant visa, then they're going to take you, set the interview. At the interview for the I-140 on the employment-based side, it's going to be a lot more simple. You don't have to prove relationships. You just have to make sure that there's a job that's available and that you meet those requirements. It's pretty smooth. It's not very, contentious unless there are problems. For example, if you had a prior immigration violation or a criminal background, then it could be problematic. But if you have an attorney with you, it should go very smoothly. A lot of Japanese restaurants do this because they really want that key chef to come from Japan. So they'll plan 2 or 3 years to bring that chef to the US and, and then have that chef work in their restaurant. So one of the restaurants I would recommend is Hinata in Indianapolis, which is just excellent. It's not sushi per se, but you can get sushi there too.
Thank you, Anthony. I'd like to stop by the restaurant when I get chance. So question to Lauren. What are some challenges could we face at the adjustment stage of the green card process?
So at the adjustment of status stage, this, not talking about the I-140, but this is just the form I-485. Some of the problems we see is that perhaps the person or maybe a family member has a criminal history. You should disclose any criminal history to your attorney. Many low-level crimes, if there's only one of them, can be excused. However, you need to disclose them. If they are not disclosed and USCIS finds out about it at any time, you would be considered to have misrepresented a material fact and you could be deportable. So very, very important that we disclose that from the get-go. Another issue would be birth certificates. In many countries, maybe not right now, but for people, I would say 30 years and older, maybe even 25, depending on the country, back in the day, there was no requirement or no standardization to register the birth. So many people obtained birth certificates maybe when they were 5 years old, 10 years old, whenever it was needed, maybe to go to school perhaps. So those people need to have some sort of other proof of birth, because for USCIS they require a birth certificate to be registered within 6 months of the birth. In that case, it's very easy. We can provide you a template for an affidavit of birth. You can have family members, family friends, religious officials, anyone who knew you at that time and can attest to your birth. So usually it's the parents, if they're alive, or an aunt and uncle, saying that, I'm the uncle and I can attest that this person was born at this time, to coincide. You can also use things like school records. Sometimes the school will also list the birth certificate, maybe your high school or something like that. Any sort of secondary evidence to prove that, yes, this actually is the correct date of birth for you. Other issues with the I-485 not being filled out correctly. Not so much anymore, but especially during the Trump administration, they were very, very picky about if all the boxes were filled out. So if you didn't put not applicable N-A in the box, perhaps your petition could be rejected and you'd have to refile it. So that caused a lot of headaches. But still, even with this application, if the filing fees are wrong, if something's filled out, you do face USCIS just sending your petition back to you. You can refile it, so no worries there, but some of these things are time sensitive. So it is really important to get it right the first time. There are, any number of things that can go wrong. We definitely recommend seek an attorney, and we can go over your petition and discuss it with you. Saki?
Okay, thank you, Lauren. So Anthony, Now I want to hear the fees. What fees are required for the I-485 and then for the DS-260, which is the immigrant visa application?
Absolutely. Let's talk about money. So for the I-485, the base fee is $1,225 or $1,225. That's for anyone who is over the age of 14 or 14 or older. Those under the age of 14, that fee is reduced to $750. Now, that's just the base fee. Now, there may be other fees, such as the medical exam you need to pay for separately, or passport photos, and things like that. Maybe you need certification of a police report or a marriage certificate or some court document. Those are sort of the ancillary fees that really aren't paid directly to the government. So within that $1,225, what are you paying for? You're paying for the application process. You're paying for them to do a background check on you. It also includes the application for the work permit and for your travel document, advance parole. So the work permit allows you to work while your green card case is pending. The travel document allows you to travel while your green card is approved. So don't travel until that's approved. Once it's approved, you can travel while the USCIS works on your green card case. Now that's the 485. That's if you're in the United States and you're adjusting your status. Adjust your status is just a fancy name for saying I'm going to change my status from my non-immigrant status to that of lawful permanent residence. I know a lot of people out there saying, the green card's not green. Why do you keep using green card? Well, it's just a term of art. Everyone's familiar with it, and it's a lot easier than saying lawful permanent resident or, I don't like using alien resident card. Those names, it's just too complicated. Everyone knows what a green card is. We know it's not green, but there is a little green on it. So, but let's move to the next application, the immigrant visa. How much are the fees there? Generally, the main fee is $325. If an affidavit is required, usually the affidavit is $120. So it's going to be $325 per applicant. Doesn't matter whether you're over or under 14. It's just $325. And then finally, certain countries may have an additional fee. So how that works is if that country charges U.S. citizens an additional fee, the U.S. will also charge them a small fee on top of that. Now, this depends on the country, depends on the agreements they have between each other, and it depends on what that country does to the U.S. So it's going to be, each time you're going to need to check to see if that's applicable to your country. Most countries do not, but some do, so check that out. So those are the fees, $325 and then the $120 if an affidavit is required for the immigrant visa. Take it away, Saki.
Thank you, Anthony. Okay, so looks like we have another comment on the chat. Lauren, can you answer this question?
Yes, so the question is in Spanish, so I'll just answer really quick in Spanish. It is a little confusing, so I'm just going to let him know probably to give us a call so we can discuss. This is a very specific case. Hola, señor Piña, gracias para su comentario. Este caso, su caso es muy complicado con muchas fechas y muchos hechos que necesitamos discutir. Entonces, favor de llamarnos en el número que está en la pantalla. If you guys could put the number on the screen. Ellos van a poner el número en la pantalla y podemos tener una conversación sobre su caso, si hay cosas que podemos hacer, cómo podemos ayudarle. Nuestros primeros consultaciones son gratis para 15 minutos. Saki?
Thank you very much, Lauren. I guess we are reaching the time now. So if you have any questions, feel free to contact us anytime. Because I know that we got so much information today and I'm learning a lot. Okay, Anthony, do you want to add anything?
Absolutely. In closing, I want to thank everyone for joining us today. This is recorded, so if you didn't have a chance to watch this live, feel free to look at it contact us. Our contact information is in the at the bottom there. Feel free to reach out to us. We're here for you guys. Things are opening up. A lot of businesses are moving forward, so start your green card process now. Don't wait. Who knows what's going to happen at the end of this year or next year? You know, we don't want to wait till the next pandemic. So get your green card case started now. Thank you so much for joining us. From all of us here at Ray Law International, have a great week, and we'll talk to you next month, all right?
Bye.